Good afternoon, and thank you for joining me for today's webinar about why an enduring power of attorney is like a form of insurance. My name is Cathy Vo, and I am a solicitor and a director at GLG Legal. I have been practicing as a lawyer for almost 17 years and providing legal advice to clients on all aspects of wills and estate planning. So, founded in 2014, Galleon Law Group has grown into a well-established law firm that specialises in property law, business and commercial law, wills and estates, family law and conveyancing. Currently, Galleon Law Group has offices in Springfield, Redland Bay and Brisbane CBD, incorporating brands GLG Legal, Bickle & McKenzie and Michael Lynch Family Lawyers under its umbrella. And we offer our clients specialised services across the legal spectrum. Today I'm hosting this webinar from our GLG Legal Springfield office, where we are dedicated to providing effective solutions to our clients' legal needs and offer specialised advice, including on the matters of an enduring power of attorney, which is covered in this webinar. So most of us take for granted our ability to make daily decisions in a range of important issues: finances, property, healthcare, nutrition, shelter, clothing, hygiene, and safety. The reality is, however, that as you grow older and experience mental decline, or perhaps as a result of injury or illness, you may lose that capacity. This is a serious issue that requires careful consideration, because unless you have put in place a trusted power of attorney to represent you, the decisions for you by others may be contrary to your wishes. An enduring power of attorney is a legal document that allows you to appoint someone you trust to make decisions for you during your lifetime if you have lost capacity. The creation of an enduring power of attorney completes your estate plan. An enduring power of attorney can often be described as having a living will. The questions we are going to examine in today's webinar are: what types of decisions can your attorney make? What are the legal requirements for the preparation of an enduring power of attorney? Who should you appoint as your attorney? What is the difference between an enduring power of attorney versus a general power of attorney? What is an advanced health directive and how does this differ from an enduring power of attorney? How must your attorneys make decisions? When does the power begin? How does my attorney use the enduring power of attorney? What obligations my attorney have while making decisions on my behalf? Can I revoke my attorney? What happens if I don't have an enduring power of attorney and have lost capacity? And what to do with your completed enduring power of attorney? So what types of decisions can your attorney make? Your attorney can make personal, including health matters and financial matters. So what I'll do is I'll just explain the differences between them. With personal matters, it relates to decisions about your care and welfare, such as where and with whom you live and the support services you may need. They also include legal matters that do not relate to your financial or property matters. With health matters, these are personal matters and relate to decisions about your health care. So healthcare includes most medical treatments, procedures and services to treat both physical and mental conditions. When you are nearing the end of your life, healthcare also includes treatments aimed at keeping you alive or delaying your breathing, such as life-sustaining treatments, or whether you're on life support and if that should be switched off if you're in a persistent vegetative state of permanent unconsciousness. With financial matters, these decisions relate to your financial or property affairs, including decisions about paying your bills and expenses, making investments such as selling or purchasing of shares, selling your property, perhaps your home, or carrying on a business. The functions that an attorney is not authorised to make on your behalf include signing a will, swearing an affidavit on your behalf, or signing a statutory declaration, consenting to your marriage, or voting in an election. So what are the legal requirements for the preparation of an enduring power of attorney? To make a valid enduring power of attorney, you must have sufficient capacity to give instructions for the appointment of your attorney. The necessary capacity to make an enduring power of attorney means that you are capable of making the enduring power of attorney freely and voluntarily, and you understand the nature and effect of the enduring power of attorney. The document must also be signed by you and witnessed by either one of the following qualified witnesses: a JP, a CDEC, a lawyer, or a notary public. Now, the witness must not be an attorney for you, nor can there be a relation to you or the attorney. The witness must also be satisfied that you appear to have capacity to make the document and understand the nature and effect of the document, and you also are capable of making the document freely and voluntarily. So moving on to who should you appoint as your attorney? There is no limit on the number of attorneys you can appoint in an enduring power of attorney, except that you can only appoint a maximum of 4 joint attorneys for a matter. You can only appoint a maximum of 4 people who must agree on all decisions unanimously. So your attorneys must have the capacity to make decisions for the matter they are being appointed for. They must also be over 18, not be a service provider for you. They must not be bankrupt or insolvent, particularly if they're appointed for a financial matter. There must not be a paid carer. Now, a paid carer is someone who is paid a fee or a wage to care for a person, but it's not someone who's receiving a carer's pension or a benefit through Centrelink. So it's always recommended to have more than one attorney to err on the side of caution. You don't want to fall into the trap where you have no backup or standby attorney in place if the only one attorney you've appointed is unable to act due to incapacity or death. Ultimately, you should appoint someone you trust, but they must be capable of making the tough decisions that sometimes comes with that responsibility. You need to carefully consider who you appoint. You shouldn't feel obliged or pressured to choose your partner, adult children, or anyone in your family if you do not think they will be able to fulfill the role for you. And there are circumstances where you may wish to appoint someone independent to manage your affairs, particularly in circumstances where there is family conflict, or there is a prior history of violence or other abuse, there is a history of addiction, gambling, drug use, or a potential attorney has difficulty in managing their own personal and financial affairs. The important questions you need to ask yourself when you nominate someone to be your attorney are: do you trust them? Do they know you well and what's important to you? Do they have the right qualities to be your attorney? So I'll go on to a case study. In this case study, Cheryl's been diagnosed with early signs of dementia. She wanted to make sure if her condition deteriorated, someone that she trusts would be able to make decisions for her when she is no longer able to do so. She loves her 2 children, but she must decide who will make decisions when she can't. Lately, her eldest daughter, Amy, has been pressuring her to sell her home, suggesting she should move into a residential aged care facility. Amy has also been hinting that Cheryl should pay down the debts which Amy has accumulated from gambling. Now, Cheryl doesn't want to do this, and she feels that Amy's own money worries would likely influence any financial decisions she would make as her power of attorney. Cheryl has then overheard her son and daughter arguing what's right for her. Now, her son Matthew clearly respects his mother's wishes, and her comfort and well-being are his first priority. Cheryl also feels that Matthew would be fair and reasonable if it came to managing the inevitably difficult decisions affecting her health. And she feels more comfortable with her son being in charge of her finances and general lifestyle affairs. Shell's gone to talk with her financial advisor, and together they've engaged in a solicitor. And although Shell has had early signs and stages of dementia, the solicitor was satisfied that she still had the capacity to understand an enduring power of attorney that needed to be prepared. Shell legally appoints her son Matthew to act as her decision maker when she eventually loses capacity. So that's an example of trying to come up with who should be appointed as your attorney and who the best person would be responsible for that role. So what I'm going to discuss now is what is the difference between an enduring power of attorney and a general power of attorney. So while both enduring and general power of attorney authorise your attorney to make decisions, there is one significant difference between the two. The authority that's conferred by an enduring power of attorney continues even if you have lost capacity. This allows your attorney to continue acting on your behalf even though you are unable to act for yourself. In contrast, if you have appointed a general power of attorney, the moment you lose capacity to make decisions for yourself, your attorney also loses the ability to act for you. Now, the general power of attorney cannot appoint an attorney for personal, including health matters. With general power of attorneys, they can only act for financial matters. Now we'll discuss the differences between what is an advance health directive and how it differs from an enduring power of attorney. There is often confusion in relation to the difference between the two. Now, an enduring power of attorney allows you to appoint someone you trust to make decisions for you if you lose capacity to make decisions yourself. Whereas an advance health directive allows you to give directions to your health professionals about the treatment you wish and do not wish to receive in the event you are unable to make these decisions at that time. You are able to give specific instructions about certain medical treatments. For instance, you might feel strongly about whether or not you want to receive life-sustaining measures to prolong your life. And these include cardiopulmonary resuscitation, that is to keep your heart beating, or assisted ventilation, and that is to keep you breathing if your lungs stop working, or artificial nutrition and hydration. Now, under the Advanced Health Directive, you can also appoint an attorney for personal, including health matters, if you have not already done so under an enduring power of attorney. If you have both documents in place and there are inconsistencies between your attorney making decisions about your health and your directions in an Advanced Health Directive, the Advanced Health Directive will prevail and have effect. So how must your attorneys make decisions? If you're appointing more than one attorney, which I highly recommend you do, you can choose how your attorneys must make their decisions. You have 4 options for choosing how your attorneys must make their decisions. So your attorneys can make decisions jointly. So in this instance, your attorneys must agree on every decision before a decision is made. They can also make decisions severally. So that means that any one of your attorneys can make a decision without having to agree with the other attorneys. That can provide flexibility. Your attorneys can also act by a majority. So in this instance, if you have more than 2 attorneys, more than half of your attorneys must agree before a decision is made. You also have the option to appoint another option, and in this option, you must specify how your attorneys must make decisions. For example, you can instruct that they make the decisions successively in the order named. So I'll give you an example of this. So Tracy has appointed her husband Richard as her attorney and her son Daniel as the successive attorney under her enduring power of attorney. When Tracy loses capacity to make decisions, Richard begins to make decisions on behalf of Tracy. When Richard dies, Richard is obviously unable to make decisions for Tracy. Tracy ticks the other box as the option and writes, I have appointed my husband Richard Smith as my attorney. If Richard dies or loses capacity, I want my son Daniel Smith to be my attorney. I've had many clients feel obliged to appoint all their children to act jointly simply because they feel it is more fair or morally the right thing to do. They don't want to hurt the feelings of a child who has not been chosen to act as an attorney. Now, if you don't think your attorneys can get along or at least be on speaking terms with each other, then I would generally advise against a joint appointment. So when does the power begin for your attorneys? For personal and health matters, your attorney's power begins only if and when you lose capacity to make those decisions. For financial matters, your attorney's power begins whenever you want it to, and you can nominate the starting date on the form. You have the option to give your attorney the power to make decisions about financial matters either when you do not have capacity to make financial decisions, or immediately, or on a particular date or circumstance or occasion, for example, when I am overseas. If you authorise your attorney to make decisions only upon you losing capacity, such loss of capacity will usually be evidenced by a letter from your doctor confirming this. There are circumstances where it may be practicable to give your attorney immediate power if you suffer from mobility issues or hearing issues, perhaps there's language barriers, or you're working away overseas in a remote area. There are circumstances where there are circumstances where it's inconvenient for you to be present if you're having to present at a bank. So how does your attorney use your enduring power of attorney? If your attorney is to act on your behalf, they will require access to the original document nominating them, or they can also get a certified copy of the document. A certified copy is a copy of the document that has been cited by a lawyer or an authorised person, such as a JP or a CDEC, and they've certified the document to be a true, correct copy of the original. The original or certified copy will need to be shown to the institution or service provider, such as the bank or aged care facility, with whom the attorney is dealing with. Your attorney will also be required to produce ID confirming who they are. If you anticipate your attorney will be required to act on your behalf, you may want to provide a certified copy of the document to the institution beforehand. In Queensland, a power of attorney will need to be registered in the Queensland Titles Registry if it is to be used for any real estate transactions. And in order to do this, the attorney will need to lodge a Form 16 request to register a power of attorney together with the original or a certified copy of the document and pay the relevant lodgement fee. Now, this process takes about up to 2 weeks. I've had several instances where an adult child who has been appointed as the attorney for their elderly parent has contacted us requesting that we register their parent's document with the titles office to enable that child to sell their parent's property and place them into an aged care facility. Unfortunately, the parent has been diagnosed with dementia, where their mental health is rapidly declining and they are no longer able to be cared for in their own home. The sale of their house is required to enable the attorney, their child, to pay for their parents' refund accommodation deposit, and that's to be paid out of the proceeds of sale to secure their parents' accommodation in an aged care facility. So we'll move on to what obligations will your attorney have while making decisions on your behalf? Your attorneys have an obligation to discharge their duties honestly and with reasonable care. Your attorney must act in your best interest. It amounts to a breach of trust if your attorney acts in a manner which is inconsistent with your known or stated wishes. Attorneys must comply with a number of duties. Some of the more important duties include the duty to keep records, the duty to keep your property separate from their own, the duty to avoid transactions that constitute a conflict of interest, the duty not to waste or give away your property, and the duty to promote your health. There is very little formal supervision of an enduring power of attorney, and so for this reason, you should have absolute trust in the person you are appointing to conduct your legal and financial matters. In the event that an attorney fails to comply with these duties, they may be investigated by the public guardian or removed by the Queensland Civil and Administrative Tribunal. If a third party believes an attorney is not acting in your best interest, they can report them and commence action with the Queensland Civil and Administrative Tribunal, more commonly known as QCAT. So we'll move on to a case study. So Michael has been nominated as his father's attorney. Michael's father has been placed in high-level aged care where all his day-to-day needs are being adequately met. After Michael's father moved into care, Michael sold his father's home and has now received the net proceeds of sale. Michael has invested part of the proceeds to meet payment of his father's accommodation charges and other expenses associated with his father's care. There is a substantial balance of funds that will not be required for his father's care. Now, assuming his father will not need these funds, Michael has decided to use his power of attorney to gift part of the proceeds of sale to himself for the purposes of renovating his own home. Because Michael has acted in his own interest, his actions amount to a breach of trust. So how can you revoke your enduring power of attorney? So revoking your enduring power of attorney is cancelling your enduring power of attorney, and you can do that at any time, provided you have the capacity to do so. The authority granted to you to an attorney can end in a number of ways. You can either complete a revocation of an enduring power of attorney form. You can make a later enduring power of attorney, which will supersede the older version. You can destroy the original document. The power of attorney is revoked upon your death. The power conferred on attorney is revoked if you get married or if you enter into a de facto relationship. You get divorced or your de facto relationship is terminated. Or the QCAT or Supreme Court orders that your enduring power of attorney is revoked. Your enduring power of attorney may also be revoked to the extent that it gives power to an attorney if your attorney either dies, if your attorney resigns, by giving you a signed notice when you still have capacity to make another enduring power of attorney, if your attorney does not have capacity for the matter for which they have been appointed, if your attorney is either bankrupt, particularly if your attorney has been given the power to make financial decisions for you, if your attorney becomes a paid carer, including if they have been your paid carer within the last 3 years, if your attorney is or becomes your health provider, or if your attorney is or becomes a service provider for a residential service where you reside. If you revoke the enduring power of attorney, you should seek to retrieve all copies of the document given to your attorney and also advise them in writing that their attorney has been revoked. So what happens if you don't have an enduring power of attorney and you've lost capacity? Unfortunately, it's too late for you to make an enduring power of attorney if you do not have sufficient mental capacity. Once you have lost capacity, the only option is for a family member, a close friend, to apply to the Queensland Civil and Administrative Tribunal, not more commonly known as QCAT. QCAT can then appoint a person to be your administrator, which is a person who makes financial decisions, or a guardian, which is a person who can make personal and health decisions. One person can hold both roles if suitable. However, the process can take some months. If there is some uncertainty or dispute about the capacity of the person, QCAT can decide on a range of matters, including making a declaration of an adult's decision-making capacity for some or all matters, that the informal arrangements in place are adequate to protect the adult, appointing a guardian to make some or personal and healthcare decisions, making temporary decisions to deal with an urgent situation, or making a declaration about the execution and appointment of an enduring power of attorney. Guardians and administrators can be appointed for up to 5 years, and they are entitled to be reimbursed for their reasonable expenses, but cannot be paid for their services. In cases where no one is available to be an administrator and or your guardian for a person who has lost capacity, the public trustee may be appointed as the administrator to manage your affairs, or the public guardian may be appointed for personal and health matters. It should be noted that the public trustee will charge fees for its role. So we'll move on to another case study. So Bill is wanting to do an enduring power of attorney to allow his wife, Mary, to act as his attorney should he lose capacity, as he is about to be placed into a residential aged care home. Unfortunately, his doctor cannot provide a letter stating he has capacity, as he currently does not. As Bill does not have capacity, he cannot appoint Mary as his attorney. Now, Mary must go through QCAT to be appointed as an adult guardian and administrator for Bill, which takes time and money that they do not have. Unfortunately, there are too many cases like Bill. Don't be like Bill and wait. Complete your enduring power of attorney while you still can. Another case study we'll go through. So George, in this instance, he's a 65-year-old man. He was single with no children. His parents were deceased. He had no siblings, no family. He loved to listen to old records and was a big fan of Frank Sinatra. His record collection was extensive. Now, he suffered a fall in his home and was admitted to the hospital, where he spent several days. On the day he was discharged, as he was about to walk out of the entrance of the hospital, he suffered another fall and was readmitted back into hospital. It was discovered that he had a bad reaction to one of the medications they gave him, which was the cause of his subsequent fall. As George did not have a next of kin or family, the hospital was in desperate need of a bed. So the doctors brought in the social worker, who made an urgent application to QCAT. QCAT deemed George to be too big of a risk because of his second fall, and it was unsafe for him to return home. Now, George's neighbours, a young couple in their mid-30s, were his only friends. They were worried about him after not seeing him for several days. They actually used to help George every now and then if he needed things such as ordinary day-to-day tasks. His neighbours contacted the Age Disability Advocates, ADA, to help advocate for George due to his incapacity. He was seen 6 months after his fall by an advocate, whilst the neighbours were still trying to get an order from QCAT. By this time, the public trustee had sold his home and his beloved record collection and placed him into aged care. We'll move on to another case study. Now, Scott is a solar panel roof installer who one hot day slipped and fell off the scaffolding on a customer's roof, suffering a serious head injury. To help slow the swelling in his brain, the emergency doctors at the hospital placed him into an induced coma. That week, Scott was supposed to sign contracts for future jobs, pay staff wages, make a loan repayment on his work truck. But Scott was unconscious in the hospital with significant head trauma and unable to make those decisions himself. This is what happened, all because he had not set up an enduring power of attorney. In the course of a week, James's financial life fell apart. His home rental, when his wife called the property manager asking for an extension on the rent, explaining Scott had suffered a head injury, the property manager issued a notice to vacate, fearing the worst and ongoing non-payment of rent. In relation to his bank loan, when his wife rang the local bank asking for an extension on a repayment, explaining that James was in ICU with a severe head injury, but as the business loan facility was a short term and was payable immediately and in full when the bank demanded it, the bank began proceedings to demand immediate payment of the loan amount, fearing he would default on payment of the business loan in future. Now, in relation to his credit card, in an attempt to make things better, Scott's wife used his PIN number to access the business internet banking and paid wages that week. As Scott was in hospital and unable to access the account himself, all transactions on the account from his admission date were deemed fraudulent, which triggered the suspending of the business credit card, which then triggered the automatic dishonour on a number of scheduled end-of-month invoice payments, including his insurance premiums and the lease on the family car. So it's financial disaster in just under 5 days. In the course of a week, Scott's financial life took a turn for the worse, and he was effectively locked out of his financial life because he had not put an enduring power of attorney in with someone he trusted. So what should you do with a completed enduring power of attorney if you've got one prepared? You should definitely keep the original in a safe place. Give a certified copy to your doctor, your bank, or your lawyer. Register your enduring power of attorney in the Queensland Titles Registry if your attorney wishes to deal with land in Queensland on your behalf. Notify your close family and friends that you have made an enduring power of attorney and where to find the document. Review your enduring power of attorney if your personal circumstances change, particularly if there's changes in marriage, divorce, or a child is 18 years and older. So there's some jurisdiction questions which we also need to consider. So each state and territory in Australia has its own legislation dealing with the preparation of enduring power of attorneys. The legislative provisions relating to enduring powers of attorney in Queensland is the Powers of Attorney Act 1998. While a number of states recognise powers of attorneys prepared in other states and territories, this recognition does not exist at a national level. Therefore, if you have assets in another jurisdiction, it may be necessary for you to prepare a relevant enduring power of attorney to allow you to nominate an attorney to transact on your behalf in that jurisdiction. Section 34 of the Power of Attorney Act in Queensland recognises enduring powers of attorneys made in other states, provided it was validly created under the relevant state or territory legislation. I've had many clients come and see me to review their estate planning documents. They have supplied me with their enduring power of attorney, which they've completed themselves, but upon examination of the document, I have found the document to be incorrectly prepared or witnessed. An enduring power of attorney is a legal document that can significantly affect your legal rights. It is highly recommended that you seek independent legal advice before completing the form. If you do decide to complete this yourself without obtaining independent legal advice, then I recommend that you carefully read the Enduring Power of Attorney Explanatory Guide to ensure that the form is correctly completed. This guide can be obtained from the Queensland Government website. It is a 28-page document, but it is a must-read if you want it to get it right the first time. You need to be prepared for the unexpected circumstances that affect your decision-making capacity during your lifetime. Failure to do so can create uncertainty and stress for family and friends in the event you are unable to act for yourself. I have often seen many clients come to see me with the intention of only having their will prepared. Many of my first-time clients mistakenly believe that their existing will somehow incorporates an enduring power of attorney or allows the executor under the will to make decisions on their behalf before they pass away. But in actual fact, this is never the case. You'll be surprised by some of the responses I will get, especially from young adult clients. They'll say, "Oh, that's only for old people," or "I don't need that now. I'm young and I'm healthy. I'll wait till I'm older." Or "I don't need to appoint a power of attorney because my spouse will automatically take on that role." You should not be complacent. Accidents and illnesses can occur unexpectedly. We all pay for some sort of insurance during our lifetime, whether it be for home and contents insurance, maybe private health insurance, car insurance, travel insurance, and so on, to cover you for when the unexpected happens. Now, having an enduring power of attorney is just like a form of insurance, and I strongly recommend you add this to the top of your to-do list, no matter what your age, status, or health. If you would like to know more information, please contact us via the details on the screen. Alternatively, if you would like us to attend your office and give a presentation on any topic related to wills and estates, please send us an email. I would like to thank you all for attending today's webinar on why an enduring power of attorney is like a form of insurance. I hope you all have a great afternoon. Bye for now.